Welcome to the Goddard Report. Comments made on the Goddard Report and TalkDigitalNetwork.com are an expression of opinion only. Here is Jim Goddard.
My guest is BC Civil Liberties Association Senior Counsel Carmen Cheung. She's the first non-government person to testify before the House of Commons Standing Committee examining the anti-terrorism law C-51. Welcome to the Goddard Report.
Thank you for having me.
So what did you tell those people on Parliament Hill about C-51?
Well, we expressed our serious concerns with many aspects of this bill. This bill is an omnibus bill, and so it clocks in at over 60 pages, and so there was a lot to go through, but we only had 10 minutes, and so we highlighted our chief concerns, which are, the threats that it poses to dissent, to expression, our serious concerns about how expansively it conceives of what security and protecting national security in Canada means, and the potential that some of the measures that are proposed in the bill may actually serve to undermine protecting Canada's safety.
Now, there are provisions in this bill that allow them to suspend the Constitution and the criminal code, and I'm just wondering, well, what kind of a law is it that allows a government to break the law?
Well, that's one of our primary concerns with this bill. The section that you're referring to contemplates a pretty radical reconceptualization of what CSIS, which is our intelligence gathering agency, would do. Your listeners might recall that CSIS was formed in the 1980s as a direct response to the findings of the McDonald Commission, which took a look at how intelligence gathering was happening under the security arm of the RCMP, and realized that there were good, sound policy reasons why a nation's police force and a nation's intelligence agency shouldn't be part of the same organization. This Bill C-51 basically reconceives all that and essentially grants CSIS police powers, and as part of those police powers, an ability to go to a federal court and to ask that court to allow it to undertake actions that might be contrary to the Constitution, which is quite alarming.
Now, this is what I know about CSIS, the Air India crash. They destroyed taped evidence, 50 reels of evidence. Now, these people are going to be back in charge of holding evidence again? They don't know how to deal with it.
Well, I think one of the things that is important to understand is that CSIS is an intelligence gathering agency, and so the way that they deal with intelligence is very different than the way that law enforcement like the RCMP deals with evidence, and that's the tension between how spies work and how police work. And that's why we keep them separate, and that's why when we are trying to engage in prosecutions and trying to do investigations for criminal proceedings, we ask our police to do that, because they work in ways where evidence gets preserved and can ultimately be used at trial. And as expert commentators like Professor Kent Roach of the University of Toronto have pointed out, that's not necessarily the way that spies work when they're dealing with intelligence.
Well, I'm just wondering, if they use unconstitutional means to gather evidence, would that evidence be allowed in court? Because right now, if it breaks the Constitution, it's tossed out.
Well, I think part of what the concern is not even whether they're using unconstitutional means to gather evidence. It's rather whether they're taking they're engaging in unconstitutional acts in the name of disrupting threats to terrorism. The limits that exist in C-51 are really thin. It basically the only limitation on what CSIS conduct can be in these circumstances is that it basically not violate bodily integrity, that no one gets killed from it, that not violate sexual integrity. But that leaves very wide open a whole range of conduct that could be unconstitutional and could just fall short of that, and that's all permissible in this bill if they can get a warrant for it.
So no death, no rape.
Yeah, essentially.
But anything else.
Yeah.
Terrific. And of course, now if this law goes through, a person can be detained by the police for 7 days without charge. Does that mean you don't get to see a lawyer?
Well, it's a little bit unclear about what the access to counsel is. Certainly, one of the concerns is that this is a very long period of time that an individual can be held without charge. Our position is that we think that if police have enough information to hold somebody, they likely also have enough information to actually arrest them and lay charges, given how broad our anti-terrorism laws already are. Our anti-terrorism laws don't just criminalize acts of violence. It criminalizes the preparatory acts. It criminalizes, conspiracy. It even criminalizes, incitement and counseling acts of terror. So if an individual is behaving in a way that that would warrant them being detained, we think that in most circumstances it will probably also warrant actual criminal charges being laid, and we would prefer to see that happen.
We'll have more with Carmen Cheung right after this.
More and more people are looking to the internet for intelligent, riveting, and thought-provoking interviews. To advertise on the Goddard Report and TalkDigitalNetwork.com, call 604-699-8600, 604-699-8600.
In Goddard we trust.
Welcome back. My guest is Carmen Cheung. She's the chief counsel for the BC Civil Liberties Association in their battle, I guess, to get changes to Bill C-51, the anti-terrorism law. Do you think this law is so onerous that it could cost the Prime Minister the election?
Well, I don't like to make political guesses. But I think what I can say is that this law is very problematic, and it's made even more problematic because there's nothing in this law, and there's nothing that's pending right now in Parliament which would address the serious accountability deficit that we have in terms of national security oversight and review. And so, on the one hand, while we have an already very broad and sprawling national security apparatus, and C-51 seeking to make that even bigger and to give our national security agencies even more power, we do not have an accountability regime that is robust enough to make sure that the things that our national security agencies are doing are legal, and also to make sure that they're effective. And then at the end of the day, that's really the most important thing for Canadians who are concerned about safety and national security and our national security. It's to make sure that whatever efforts we undertake to protect our public safety actually work. And right now, we don't have a system that really allows us for us to see that.
Has the government given any examples of why they have to change the current laws?
As I have seen, the government has primarily simply asserted that these powers are necessary without really providing any concrete examples of how what acts might have been thwarted if but for these laws, and why these laws are absolutely necessary. I mean, one of the things that I think is important for us to consider and for Parliament to consider as they're examining this bill is really whether what we're suffering from is not enough laws, or rather it's an operational issue. Whether the existing laws we have are simply not being deployed in the best way possible.
Any evidence that Bill C-51 would have stopped the shooting on Parliament Hill?
That's something that we were hoping would have a bit of a better explanation from government, but unfortunately that's not something that we've seen so far.
I've heard some of the conservative members of the House during debate on television about Bill C-51 saying, well, yeah, it does go kind of a long way from what we're used to doing. And if there are any problems, and I'm sure there will be, we'll correct them at the right time. Just trust us to do the right thing.
Right, and I think that the problem with enacting very broad legislation like this is that it's much harder to get it corrected after it's enacted, either through the parliamentary process or through the courts, and so it just seems to be the more prudent thing to make sure that whatever we're enacting is not only constitutional but makes sense, so that we wouldn't be forced to have to revisit it and to correct it later. I mean, one thing that I will point out is that there isn't even any provision in C-51 to revisit any of these provisions later on in the future. When the original Anti-Terrorism Act was passed in 2001, there were sunset provisions for the most controversial and extreme measures, automatic expiration of those provisions, because they were recognized to be quite extraordinary powers that were given to government, which include preventative detention, which is in this bill.
Now, what happens if a person is detained for 7 days and they're completely innocent? Could they sue for wrongful detention? They've done that in the past. It's cost the government millions of dollars.
Well, I mean, I think that remains to be seen. We haven't really seen a very robust application of the preventative detention provisions that already exist. Right now, C-51 only is trying to expand the preventative detention regime. Canada already has preventative detention powers. What C-51 does is basically just lower some thresholds and make the period that someone can be held longer. But the extraordinary powers to preventatively arrest and detain individuals already exist in Canada.
Oh, so in other words, like I said, they don't have any examples of why they need a stiffer law. And I can see police forces abusing this pretty easily. Tell us, who your buddies are, or, we'll call you a terrorist and put you in jail for 7 days without a lawyer.
I mean, certainly that's one concern that rights organizations have raised. Because
this has happened in every jurisdiction that has similar laws.
I mean, we've seen examples of abuse of preventative detention measures that there's risks that they turn into a way to get around the requirements of an investigative hearing and requirements and due process protections for individuals who who might be asked to testify against themselves or provide information that they don't want to. And so those are all concerns that not just us, but legal scholars and other human rights organizations have pointed out to the committee in their submissions to them.
Do you think this is going to end up before the Supreme Court of Canada?
Well, as I understand it, yesterday after his testimony, the Assembly of First Nations indicated that they were considering a charter challenge of this legislation if it passes, and so it is quite likely that if they proceed as planned, this might all end up before the court.
And I didn't hear a lot of consultation about this law either. You were only given 10 minutes to address a 60-page law.
That's correct. All the witnesses were given only 10 minutes, and a good number of witnesses were not called at all. The privacy commissioner, who has come out quite strongly in his criticism of the information sharing aspects of this bill, has not been called, and despite repeated requests that additional time be added to committee hearings so that he could be called. Other organizations that have a lot of expertise on these issues, like the Canadian Bar Association, for example, or the Criminal Lawyers Association, they haven't been called either to testify. So we are very concerned that a lot of voices are not going to be represented in these hearings.
This sounds a whole lot like during the Mulroney era when they brought in stiff child porn laws just before the election. They were told this thing's seriously flawed. People are going to walk away because you haven't closed all the loopholes, and sure enough, people did. Even though the law looked tougher, it let bad people go. This one here, if it's challenged in the courts, could eventually see bad people let go too, couldn't it?
Well, I think that one of the concerns is that we just don't know. Because the provisions are so broad, it captures a lot of conduct and a lot of speech that may never look like what the ordinary Canadian thinks of as terrorists, and so we might end up targeting the wrong people. We might end up targeting too many people, and we might end up just wasting resources trying to chase down leads that really aren't security threats at all. But because of sort of the expansive way that this act conceives of what security means, and what protecting national security means, we might see a lot of those wasted resources.
Well, I could see a political science class being busted by this law. You just discuss it, and of course people could say, well, sometimes there's legitimate reasons for people to be in revolt against the government. But if I say I support that, I'm now a terrorist if my government doesn't like that particular freedom movement, right?
I mean, that is certainly a concern that we have.
I mean, just recently, the civil war in Sri Lanka that took tens of thousands of lives. I guess if you supported one side or the other, you could be branded a terrorist.
And I think that is one of the concerns when you have a law which, and I think what you're addressing now is the speech provision, the new offense that's being created, that would criminalize any speech acts or any act of expression that would either promote or advocate, terrorism in general. Some of the concerns with that provision have been with the idea of terrorism in general, because no one really knows what that means. It's not really tied to any existing concept of terrorism that we have in our criminal code, for example.
What if you write a movie about something like this? Does that mean that you're proposing violence?
Well, it depends on whether whether the listener or whoever's watching your movie or listening to you talk, might be liable to commit an act of terror. The problem with that provision right now is that it places very little limits. There's, the speaker is not required to actually intend an act of terror to happen, and the listener himself isn't actually required to go and carry out an act of terror. All that's required to trigger this provision is that an individual has spoken in such a way that can be considered advocating or promoting a terrorism offense to somebody who may likely be carrying out a terrorism offense, and that's those are incredibly vague and broad provisions.
Sure, I mean, I could see the people at Saturday Night Live being busted for so-called promotion of terrorism just because of that parody ad they did about ISIS 2 weeks ago.
Yeah, I mean, I think that one of the things that government has been saying is, we're obviously not going to be going after kids on Facebook, and that's not, and things like Saturday Night Live isn't the kind of thing that we're going after. But our concerns are that that's really just up to the discretion of a prosecutor, or up to and if it comes down to just simply prosecutorial discretion, that means that individuals really have no good sense of where the boundaries of the criminal law are, and that's an important thing when it comes to talking about what is criminal conduct and what isn't, because it helps people guide their actions. And so if people really have no sense of what is going to be okay and what isn't, then that necessarily chills expression.
Well, it just reminds me of the Jon Stewart movie Rosewater, where an innocent person in Iran is accused of being a terrorist, and they misinterpret everything he does as being the act of a terrorist, and security officials are not known worldwide for their sense of humor.
Yeah, so, I mean, I think that what you're pointing to is really, our chief concerns with the bill, that that they're just so open-ended, and so much of it is left to the discretion and judgment of whoever is applying the law, that it's just difficult for individuals to make sure that they're not on the wrong side of it. And for us, that really means that the bill has to go back to the drawing board.
Carmen, is there a website people can go to find out more about the Liberties Association's stand on this?
The BC Civil Liberties Association's website is bccla.org, and all of our submissions on Bill C-51 are up on our website. We also have a blog where we've set out our 8 main concerns about this bill, and then about 1,000 words or less, which may help people learn a little bit more about what our primary concerns are.
Thank you very much for speaking with us.
Thank you.
My guest has been Carmen Cheung. She's the senior counsel for the BC Civil Liberties Association on their front on Bill C-51. You're listening to the Goddard Report on TalkDigitalNetwork.com. Find us on Twitter at TalkDigitalNet. Check out our popular YouTube channel, Talk Digital Network. Comments or questions for the show can be sent to info@howstreet.com. I'm Jim Goddard.
Comments made on the Goddard Report and TalkDigitalNetwork.com are an expression of opinion only. The Goddard Report is available online and mobile at TalkDigitalNetwork.com. The Goddard Report is a production of How Street Media Incorporated.